I'm Ben Meiselas from the MeidasTouch Network. On Friday, Donald Trump filed in the Florida federal case before Judge Aileen Cannon relating to his theft of government records, national defense information, classified records. He filed a motion that is styled as the following: President Donald J. Trump's motion for a revised schedule for motions to compel and CIPA Section 4 litigation. He's not the president. If he wants to say former president, I still think it's disgraceful, but he can say that. But he's criminal defendant Donald Trump. So what is he asking for here? What is this motion about? This is about delay, folks. And I'll explain to you what Section 4 of CIPA is, what Donald Trump is claiming here. But I think a little bit of background is important. Remember, Donald Trump was indicted back in June of this year in connection with obstruction of justice, making false statements, and the willful retention of national defense information at Mar-a-Lago. Immediately, Special Counsel Jack Smith wanted to have a protective order entered and also wanted a CIPA protective order because Donald Trump stole classified information, and the case relates to classified documents. It falls under special procedures under the Classified Information Procedures Act, or CIPA, and there's a special Section 3 CIPA protective order that deals with the handling of classified information. It talks about the appointment of a CISO, a Classified Information Security Officer. And so from the outset, Jack Smith's like, we need a protective order right away, how these documents are handled, because obviously classified documents need to be handled in a very sensitive way. How do they get filed? They obviously can't be filed in public. Even if they're filed what's called under seal or in a confidential way, how do you make sure there's no leakage? How do criminal defendants access classified information which don't belong to them, belong to the government? They have to look at them in SCIFs, sensitive compartmented information facilities. So CIPA sets forth all of these rules. Jack Smith right away is like, let's make sure that we get the CIPA protective order entered. So Donald Trump and Donald Trump's lawyers have to submit, specifically Donald Trump's lawyers, have to submit all of these documents to get appropriate clearances. Trump doesn't. The lawyers need to get the appropriate security clearances in order to be lawyers on the case and to view these documents in SCIFs, sensitive compartmented information facilities. Trump's lawyers took like 45 days. They took a really long time before even getting their paperwork in. Maybe a slightly less than that, but they took a long time. They finally get their paperwork in, and then Judge Aileen Cannon has no clue what she is doing at all. She's never presided over a CIPA case, so she improperly sets a hearing on a CIPA protective order for August of like late August, and then she realizes that she's not able to do these hearings in public. So then she then has to reschedule the hearing that was supposed to take place on August 25th, 2023. She then reschedules the hearing under seal in a way that's befitting of classified documents on September 12th. And it finally takes Aileen Cannon from June to September 12th to finally enter the CIPA protective order, which means that it was only until September 13th, when the protective order was finally entered, that Special Counsel Jack Smith was able to turn over the classified records or make them available in SCIFs, sensitive compartmented information facilities, to Trump's lawyers for Trump's lawyers to review. And there's not that many of these records that are the CIPA records. On all of the other discovery has pretty much been turned over to Donald Trump in this case already. So the issue now is what's called a CIPA Section 4 issue. Stay with me. I'll explain what Section 4 is. So under CIPA, Section 4, it relates to discovery of classified information by defendants. And what it says is, this is what Section 4 of CIPA says: the court, upon a sufficient showing, may authorize the United States to delete specified items of classified information from documents to be made available to the defendant through discovery under the federal rules of criminal procedure, to substitute a summary of the information for such classified documents, or to substitute a statement admitting relevant facts that the classified information would tend to prove. The court may permit the United States to make a request for such authorization in the form of a written statement to be inspected by the court alone. That means ex parte, for the court to look at it alone. If the court enters an order granting relief following such an ex parte showing, the entire text of the statement of the United States shall be sealed and preserved in the records of the court to be made available to the appellate court in the event of an appeal. So basically what this means is that because some of the classified information is so sensitive, the government in some of these cases doesn't even want to show it to the defendant who engaged in a crime relating to the classified information. Instead, what the government wants to do is just provide a statement that's agreed on to the judge, so the judge recognizes that the government is providing an accurate statement summarizing what the document says, and to basically use that summary in lieu of the actual classified document, so that the defendant doesn't really get to even access the actual document. They get a summary of it because there's a fear that if the defendant has access to it, they're going to engage in more mischief and more criminal conduct. But you have to make a showing to the court.
And now let's take a quick break to talk about our next partner, Fume. Cold turkey, it may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo from your wacky neighbor or some sketchy message board. We're talking about our sponsor, Fume, and they look at the problem in a different way. Now, not everything in a bad habit is wrong. So instead of drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, Fume is completely natural. Instead of vapor, Fume uses flavored air. And instead of harmful chemicals, Fume uses all natural, delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I used Fume, I was shocked at how flavorful and fresh it tasted. Now, it's easy to hold and perfectly balanced and quite honestly, extremely fun to fidget with. The real wood material and sleek design definitely classes it up, and I feel pretty darn cool holding it. Stopping is something we all put off because it's hard, but switching to Fume is easy, enjoyable, and even fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com and use code Meidas to save 10% off when you get the Journey Pack today. That's tryfum.com and use code Meidas to save an additional 10% off your order today.
So here, what Donald Trump is, he's acting like in this motion he hasn't received all these documents and the government's not turning it over. That's not the case. What seems to be happening, again, we haven't heard from special counsel Jack Smith yet, but from Trump's motion that's publicly filed, and arguably this should have been filed under seal, but from what Trump publicly filed, what the government wants to do is just have these summaries of the documents instead of giving the classified records back to Donald Trump, because likely the government fears that Donald Trump will use them for an improper purpose. So that's what Trump is whining about here. And on that basis, in this motion, Trump is basically saying, I want an order compelling Jack Smith to turn over the actual documents, not the Section 4 summary, the actual classified documents, mind you. That would still be subject to the CIPA protective order that Judge Cannon just entered on September 13th. So Trump would have to go to a SCIF to review it, a sensitive compartmented information facility with his lawyers. There'd be other limitations placed on it. But he doesn't want the summary. He wants the documents. So here's the argument that Trump makes. Trump submits this motion and the accompanied classified classified supplement filed under seal, pursuant to the court's instruction on September 12th, seeking an adjusted schedule for defense discovery requests, motions to compel, and motions pursuant to Section 4 of the Classified Information Procedures Act. This motion arises from the unjust efforts by the special counsel's office to foist rushed CIPA litigation on the court. Trump and his co-defendants. Early in these proceedings, the office boldly asserted that it had all the discovery, was able to produce it, and was ready to go to trial. Pause there. It is. It has all the documents. It's just going through Section 4 procedures, which I outlined earlier in this video. Twice, the office committed to promptly producing all witness statements, even if the statements would not be deemed discoverable under 18 U.S.C. Section 3500. Yes, they did. So what? What's your point? Get to your point, Trump. The current schedule for discovery, oh, you want to delay. The current schedule for discovery litigation and CIPA Section 4 practice would only have been feasible if the special counsel's office made good on those promises. Yet 2 months later, it has not done so. Oh, I wonder what has happened in the 2 months. Maybe Judge Cannon hasn't entered the order until 9 days ago, until 10 days ago. Jack Smith wanted to turn it over sooner. So let's just address that issue. And then it says, and there appear to be significant unresolved disputes regarding the appropriate scope of discovery. Nevertheless, the special counsel's office has not backed away from its assertion that on October 10, 2023, pursuant to the current schedule, it will seek permission to withhold materials from Trump that are subject to the office discovery obligations in this case. The office has indicated that it intends to rely on CIPA Section 4 in connection with that motion and to ask the court to determine, based on an ex parte submission, whether the materials at issue is inter alia, means among other things, relevant or helpful to the defense. Ex parte proceedings are generally disfavored, and this type of motion presents an additional challenge, requiring the court to assess potential defenses to the pending charges without benefit of a truly adversarial process. It's the statute. I read the statute. Section 4 of CIPA says that the court may permit the United States to make a request of such authorization in the form of a written statement to be inspected by the court alone if the court enters an order granting relief following such an ex parte showing. The Jack Smith just following what the statute is. And really, when you get to the heart of what Trump's asking for, here it is right here. Trump respectfully submits the following revised schedule for discovery litigation and CIPA Section 4 practice is necessary to provide sufficient time. And then it basically says, here's the revised schedule, and they want to delay all of the things and push these motions related to classified information to January 19th of 2024, which it doesn't say in this motion, but that will have the effect of pushing all of the other deadlines back, including the trial date. So it's more delay. That's what Trump is seeking to do here. And again, we'll see what Judge Aileen Cannon does, but also Judge Aileen Cannon waiting. I'll do a whole nother hot take on this, but like the malpractice of Judge Aileen Cannon not entering a protective order allows Trump to make the argument, oh, Jack Smith hasn't turned it over in 2 months. Jack Smith turned it over right away. That protective order was entered on the 13th by Judge Cannon. And by the way, Section 4 of CIPA allows Jack Smith to do this. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. You see, you're a CIPA expert right now. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.